Ms. Barrett, I want to interrupt you. I apologize for it.
All right.
This is a very special occasion in the history of the Fourth Circuit. And before you get to your argument,
Okay.
I hope the clerk won't charge you any time, this will be the last, in all likelihood, the last occasion for Chief Judge Gregory to preside over a panel of this great court. For 7 years, he served with distinction beyond measure for the Fourth Circuit Court of Appeals. And Judge Motz and I have served with him since he was appointed, initially by President Bill Clinton as an interim, there's a special title for that. Recess appointee, a recess appointee. The first recess appointment to a judgeship in the United States was made to Roger Gregory, the first one since Earl Warren was appointed to the Supreme Court by President Eisenhower. But Judge Motz and I are honored to be here today to serve on this panel. And I wanted to make that point if I could, Judge Gregory, and I apologize for interrupting.
Thank you, Judge King, for your kind words, and thank you, Judge Motz, for your friendship and collegiality over the years, both of you. And thank you very much.
Judge King and I were arm wrestling about who would say that. He won. But he is also now senior to me since I took senior status, you know. So he gets the honors, but it is a huge honor to be with Judge Gregory today.
Thank you.
I'm happy to hear from you. Thank you.
I must say, if I'm seen today, it's only because I stand on two very strong, broad shoulders to my left and right. Thank you so much. Ms. Barrett.
This is a drug trafficking case, as you know, out of Graham, North Carolina, Eastern District. It all started, as many drug trafficking cases do, with a traffic stop. And the appellant, Mr. Davila, was stopped for speeding as he left his home, and a search of his car ensued, and following that, search of various houses that he had named as places that might have drug activity. It should be noted that he is not an English speaker. He strictly speaks Spanish. Everything has been interpreted or translated for him in this case since I've had it. I'm not sure that that happened all the way through the trial court, but it should have, and that could be a reason for assignment of error as well. He was charged based on statements from co-conspirators or confidential informants giving information that led to the indictment on 3 counts: possession, conspiracy of cocaine, and a gun charge, possessing a gun to further those crimes. He quickly signed a plea agreement and pled guilty to all 3 charges. Unfortunately, there was no factual statement written up or signed by either of the parties. So to look for the facts, we have to look at the hearings that took place before the trial court, and otherwise, we've got the statements that were given to the probation office by the government in preparation of the pre-sentence investigation report. And Mr. Davila did not sign off on any of that information. There was no factual basis to incorporate it into the plea agreement. That's a big problem for Mr. Davila, because it's hard to say if there's not anything on the record, what did he do wrong? We're left with, what did he do wrong? Well, we don't really know, but that is a potential problem that the court can resolve by sending it back for further proceedings. And I just want to point out that this is the entire record in this case. It has everything that happened in this case in these two little pamphlets. I don't think I've ever gotten a record on an appeal to the Fourth Circuit that had this few pages to it and said so little. And that is the biggest problem, that the trial court did not say enough. And to illustrate that, the plea hearing was combined with arraignment for Mr. Davila and another defendant. It's not clear whether that was one of his co-defendants, but that entire plea hearing started at 10:29 a.m. and ended at 10:24 a.m. on the same day. That was a total of 15 minutes for arraignment.
Say those times again.
10:29 a.m. and ended at 10:44 a.m.
10:44. Okay, I thought you said 10:24. Okay.
44. So
15 minutes for the Rule 11 hearing?
Yes. And that,
And you claim that's an invalid Rule 11 hearing?
yes, I do. Not so much because they,
As to the conviction, that's your claim here,
yes,
that the
absolutely.
plea is invalid.
That's right. That's right. The rules requiring what has to be covered in the plea hearing just weren't followed to the letter at all. Everything was summarized. It's unclear whether there was any conversation between the translator and Mr. Davila. I don't see how there could have been in 15 minutes to have gone through anything.
Did we review that for plain error? Wasn't preserved. You didn't make this claim in the district court at all, did you?
No. No.
Okay.
And then
So what's that mean? What's that do to your claim up here? The fact that you wasn't raised?
well,
No complaint about
right.
propriety of the Rule 11 hearing in the
Exactly,
district court.
exactly. But what we're saying is that he's got a right to due process, and due process wasn't had in this case. There just wasn't enough in the hearing.
Well, if there's error in the hearing, is there a question of whether it satisfies the plain error standards, or whether it satisfies harmless error or something like that? If there was some common error.
Plain error.
I mean, the government's going to say what?
I don't know what they're going to say.
You don't know what they're going to say. You haven't seen their brief?
Oh, yeah, yes, I do. I don't know what they're going to say today, but they've
What
said,
is their argument, as you understand it?
their argument is that everything was up to code in the hearing, that that he pled guilty, and therefore we can't question what happened at the hearing. That's their basic argument.
Unless, of course, it rose to the level that it's not voluntary, right? That's your argument.
Yes.
And you'd have to do so in a plain error standard, but that's how high you'd have to jump to win. And so you're saying that the paucity of the time spent on the Rule 11 colloquy is a factor we should look at in terms of whether, and his English, not being able to speak English, those things should factor into the involuntariness. That's your position, correct?
Yes. There was actually one point in that hearing where the judge asked him if he was in fact guilty, and he said yes, and then, but we don't know if that was after conference with his attorney or the translator, either one. And then there was a question about, so you actually committed these crimes, and he couldn't answer it. And the judge had to stop the proceedings for a moment. I don't know how long, but within the 15 minutes, if there was some stop for further conversation to clarify for him what the question was. And all that came back from that was his attorney said, it's a language problem.
I don't mean to get between, and certainly not, and you can, just respectfully not comment on it, but I do want to know, your client understands if you prevail on what you're asking this court to do, does he realize he starts at zero again, that no plea agreement, none of those things are happening, and that, because the sentence here was, well, you know what I'm talking about. Does he know that? That all, accepting responsibility and all those kind of things?
Yes,
Right?
sir. Yes, sir.
That's a risk, isn't it?
Well, the request for relief has two parts to it.
Oh, yeah, the gun, you mean.
Well, there's the gun charge that I addressed separately in the briefs, and in my opinion, the evidence did not prove that that gun was ever used by Davila at all, much less to further criminal activity. He was never even recorded or seen by anybody selling or receiving drugs. There's nobody that testified, although the government said there were many people that told them. Well, that's all hearsay. They didn't come and testify. There was no written affidavit from any of those people. They were, for the most part, unidentified. And in my opinion, that's not a factual basis for being convicted of that charge that carried a
You
consecutive.
think he could be acquitted at trial then? You'd be
Yes.
willing to
He should.
get a trial and plead not guilty and go to trial? I mean, that's where you could end up. And all this is past history, and he can get the maximum.
That's a good point that you make, and it concerns me, and I'm always concerned about what would happen if I win, because I don't know if I would have done any good for the client. Not that.
You're like the dog that caught the car.
Yes, exactly. But in this case, I do think that there is not enough factual basis sufficient to convict on the gun charge. And I understand that he entered a plea agreement to all three charges. But his attorney was at fault, in my opinion, for letting him sign that agreement and encouraging him to sign that
There's no
agreement.
ineffective counsel claim here. We don't have an ineffective counsel claim.
Yes, we do.
We got a claim that the plea's bad. It's involuntary. I thought that's what you just said. The Rule 11 plea is defective because it was involuntary. But that's your claim.
Yes,
You want the conviction vacated on the basis that the plea's bad.
I have several bases which you may reach that conclusion with. One is involuntary. One is lack of factual basis. One is lack of counsel, and ineffective assistance of counsel, and the lack of
But
procedure.
ineffective assistance counsel is normally not considered on direct appeal. It'd be very
I
exceptional to
understand.
get that into a direct appeal. But you do have a right to appeal and say that the plea is involuntary, and you've been appointed. You mean you're going to raise whatever you need to raise, and you haven't.
Right.
But as my understanding, that's what you're trying to get at with respect to the conviction. That the conviction's flawed because of the defective plea of guilty.
Would you care to address the sentence?
Yes.
Okay.
Yeah, what we're asking is for the sentence to be vacated.
I know what you're asking, but you have to give us, what I'm asking you to do is address your argument
Okay,
with respect to the
okay.
sentence.
Yeah, well, because he pled guilty to all three charges, the sentence contained concurrent sentences on the first two charges, and then a mandatory consecutive sentence on the gun charge. And because the factual basis is insufficient on the gun charge, I'm of the opinion that the sentence on the gun charge should be vacated and the case sent back for resentencing on that point. I would, whatever the court decides to do is what the court decides to do, but from where I stand, looking out for the best interest of Mr. Davila, that charge should be vacated as well
Well, remember we asked you particularly to address Rogers. Do you have a Rogers argument you'd like to make to us?
Yes. The Rogers argument was very revealing to me, I'll tell you that. I really especially appreciated the language that said that it's a complicated typology to figure out what special conditions of supervised release are mandatory and which ones are not mandatory. And I guess I counted on the district court in the written judgment to list mandatory and non-mandatory in separate places. As it turns out, they don't do that. And you have to go back and look at what the statute says is a mandatory. That's what the Rogers case did for me, was to tell me what's mandatory and what's not mandatory as a condition. And if it's a non-mandatory condition of supervised release, then the Rogers case says it has to be announced at sentencing, at the sentencing hearing, so that the defendant has an opportunity to argue against it. And that wasn't done on several of the conditions.
I think the government says that there's one condition that wasn't done on. Do you disagree with that?
I do.
Okay, maybe you can tell us what conditions. It seems to me that's an important, at least I think I'm remembering the government's argument in that respect.
I'm sure that's what the government argued, but. Okay, the mandatory conditions were by statute, 4 of them, not to commit I'm almost out of time, but I'd like to finish.
You may finish.
All right. The 4 mandatory ones we don't have a problem with. Those were announced, not discussed, but announced at the sentencing hearing. Those were authorized by 18 U.S.C. 3583D. Then below that paragraph in the judgment was a list of what it called standard conditions of supervision, which doesn't really answer the question of what is mandatory and what's non-mandatory.
Were they announced? Were they announced, those additional ones?
No, they weren't.
So that's what your question is, between announced
Right.
and what was he was actually sentenced to, right?
Yes.
And so how many of them are not announced?
There are 13.
Or 19, but anyway.
13 or 19? I think
13, okay,
I said 13.
okay.
There could be more. And so those, because those weren't addressed at the hearing, they're invalid and cannot be imposed unless it goes back for resentencing and the sentencing hearing is done properly.
They're contrary to Rogers.
That's true.
And the relief you seek, discussed in Singletary, did you find that one?
Let's see here. I may have Singletary.
Well, that's all right.
I didn't, it rings a bell, but I didn't discuss
So
it.
what you want us to do what?
To vacate the sentence and send it back for resentencing and to vacate the conviction on 924.
If we don't vacate the conviction, what do you want us to do?
Vacate the sentence, the whole sentence, and send it back for resentencing.
Well, at resentencing, can't the district court correct the error?
I'm sorry, say that.
If we send it back for resentencing, could the district court then correct the error?
Yes, they could. But that doesn't mean that Mr. Davila isn't entitled to due process.
No, I understand that.
And
I thought maybe you had an argument that they couldn't do.
No, I don't. But the biggest problem I have, is that Mr. Davila is due to the same due process as every other criminal defendant. And the fact that this was handled so poorly at the hearings, it just enforces the public's opinion that the justice system is all screwed up, and that particularly minorities have no chance of getting a fair trial. In this case, he didn't get a fair trial, so they're right. And I don't think that's a message that the court ought to send to the public. Any other questions?
Ms. Barrett, I just want to make
Yeah.
very clear
Okay.
of just in my mind. Other than the Rogers question, your argument you have, are you saying there's another way that you can win without having to be subject to a trial on the other two, the gun and the plea and everything? Are you saying you, because you said, well, I want the whole thing sent back for resentencing. But now, Rogers, as Judge Mott said, that could be corrected by then saying either they're gone for right now, but now I'm going to tell you exactly in court, this condition applied. But the other two, if you win, can you avoid a trial? Don't you have to then be subject to being tried on the gun part?
He would have an opportunity, excuse me for interrupting, he would have Mr. Davila would have an opportunity to renegotiate his plea, a new plea, with effective counsel. And I think that's what he deserves.
Yes, yeah, that's true. He would perhaps have an opportunity, but, might not be happy campers on the other side.
That's a risk he took when he filed for appeal.
Okay, that's all. Thank you. That's mine. That's good.
No, thank you.
Thank you.
Thank you. Thank you, Ms. Barrett. Mr. Gibbons?
Thank you, Your Honors. John Gibbons for the United States. I'd like to start off with the Rogers issue that Judge Motz brought up at the end of counsel's argument. First and foremost, as we said in our brief, we would argue that the Rogers issue has been waived. Obviously, the general rule is that any issue not raised in an opening brief is waived.
Okay, so is that the basis for your waiver argument?
Certainly.
Is that the only basis for your waiver argument?
Well, I mean, if you look at how this case progressed, Mr. Davila was sentenced 9 days after the Rogers decision originally issued. So this argument has been available to him at every step of this case when his judgment came out, when his counsel filed the Anders brief, when he filed his own, and when counsel here filed the supplemental brief. And it was never raised. And, there are strategic...
Why didn't the government raise it?
Well,
I know you need to answer Judge Mott's question, but
well, it's
I
defendants.
think in this case, the government had an obligation to raise it. That's my view of the duties of the prosecutors in this court and in the district courts. You have an obligation to do justice
Certainly.
over and above everything else.
Absolutely, the department does have an
And 9 days
obligation.
before you knew what Rogers said. Basically, it's in, if you put these things in there and they're not in the record, not specified, it's in sentencing in absentia, right?
Of course, yes.
That's what it is.
I agree that the prosecution...
No question the defense lawyer should have brought it up. No question at all. There's also no question the government should have brought it up, in my view.
Well, I would certainly agree that the government has an obligation to do justice, but it is defendants...
You say that doesn't include telling the court what the controlling authority is.
Well, we did tell the court what the controlling authority was in response to the supplemental briefing request. And, it is defendant's obligation to raise the issues on appeal that he wants to raise. And, there are strategic reasons why perhaps he wouldn't have wanted to raise this particular issue, because it would only get him a resentencing where he had already secured a very favorable plea deal. He was sentenced to 100 months plus the 60 months, which by statute must be consecutive to all other sentences. So that's 160 months total, where his guidelines was 180 to 235 plus the 5 years consecutive. So he's already secured a very favorable plea deal. It's very reasonable to say, I'm going to, I have this great plea deal. I'm going to, stick with what I have unless I can get a conviction knocked out too.
See, I hear you, and I think that's a fair argument. But in this case, the Rogers error, of course, is curable. So if you had made the argument and it had gone back to the district court, and the district court had, or you confessed error, gone back to the district court had done it correctly, that wouldn't be a problem in front of us, right? So it strikes me that the government might be to your advantage ultimately. But I know it's hard at the time.
Certainly. And, I would also say that the defendant could have asked to amend the judgment as well. When the judgment came out, compared it to the conditions and could have asked to amend the judgment.
But that's not what he wants. He wants a bigger benefit than amending the judgment.
And
he wants to point to that as error. But you say, well, yeah, but that's curable.
Well, and that's another reason why we think that the general waiver rule should apply here. There were multiple opportunities to raise this. The defendant, for whatever reason, didn't. And actually, if you look in the council supplemental opening brief, it has on page 6, it says, the judgment was filed June 11th, 2020, and this is a quote, as handed down in court with no additional special conditions included. Now, obviously, if the court were to reach this, we would disagree with that. We believe that there is one condition that was not orally pronounced. But that just underscores the point that this argument was never raised. We don't know if, based on the timing of the supplemental briefing order and the supplemental briefing, it's not even obvious from the submissions that defendant has had a chance to weigh in on whether he wants to pursue this argument. So the government's position is that this is waived. And going to the factual basis argument under the 924C charge, Judge King, you're absolutely right. Because defendant did not waive these issues below, this is reviewed for plain error. And that's obviously a very high hurdle to jump over, like Judge Gregory was discussing. The district court also, in addition to the plain error posture, has a very deferential standard of review already. The district court is only required to be subjectively satisfied that a factual basis exists. And this court reviews that if objected to below for an abuse of discretion. So you've got that plus the plain error argument that counsel has to jump over here. And because
what prong of plain error does the government rely on?
For the factual basis argument, we would say that there is no error at all.
No error?
Yes, sir. If you look at the Lomax factors, which are
Prong number 1.
Prong number 1, 2, 3, and 4. If you look at the Lomax factors, they tell, so this is what the evidence at trial would, what kind of evidence could show that the firearm was possessed in furtherance of the drug crime. Lomax says you look at the type of drug offense, the type of gun, proximity to drugs and drug proceeds, accessibility of the gun, illegal possession, whether it was stolen, whether it was loaded, in general circumstances. And you look at the whole record under the Supreme Court's case in Vaughn, because this is on plain error. And so you see almost every single one of these Lomax factors we've got in the record. You've got a sprawling, so type of drug offense, sprawling interstate conspiracy, taking drugs from Mexico to Texas to here, with distribution quantities of cocaine and marijuana. I mean, these were a lot of drugs, kilograms of cocaine. This was not, personal usage amounts, and the cases are clear that, a high-level dealer is more likely to have a firearm in furtherance of a drug crime, just because guns are tools of the trade in drug trafficking. The drug dealers have valuable products on them. They're the targets of robberies personally, and for obvious reasons, they can't call the police if a dangerous situation arises. And so it's, based on the nature of the offense, we can, that alone supplies a sufficient factual basis. You look at the type of gun, it was a handgun, which can be easily concealed, carried to transactions. It wasn't, like a wall-mounted antique musket or anything. You look at proximity to drugs and the drug proceeds. It was found in the same room in the master bedroom of defendant's residence with $14,000 in cash. And defendant, we know from the PSR, had no other significant sources of income. You look at accessibility, it's in his master bedroom. Illegal possession, we know from the Rule 11 hearing that he was an unauthorized alien, and under 18 U.S.C. 922 G5A, his gun possession was illegal. You look at the general circumstances surrounding the possession. I mean, he was targeted as part.
And excuse me, counsel, where is it that it was in the master bedroom?
It does not say specifically.
Well, wouldn't that be important from a factual standpoint? The Lomax factors, proximity is a physical element there, right?
Sure.
Why is that not in the record?
Well, and at trial, that would have been something that counsel could have.
But the court needs to be convinced, even at the plea stage, that there are sufficient facts that make this a valid plea. You agree with that?
Absolutely.
Well, why is it in the record? Because that's the sine qua non, isn't it? How close was it? Now, I know the Fourth Circuit says that guns and drugs go hand in hand, so you don't have to make a strong argument on that. The Fourth Circuit precedent has done that for you. But it doesn't mean that every drug trafficker has one. So it is tempered by having this proximity aspect of it. Why wouldn't that be in the record? It's not in the record that is in it. Where is it?
Well, I would give two responses to that, Your Honor. The first is that for a Rule 11 factual basis, the Fourth Circuit has said that the trial court doesn't need to replicate the trial that the parties have agreed to avoid.
Absolutely.
And so the fact that defendant...
The court needs to comply with Rule 11.
Of course, yes. But the fact that the defendant, and so this is my second point, the defendant wasn't contesting any of this information. He was pleading guilty. The district court asked him specifically, are you actually guilty? And he said, yes, sir. And so, when you tell the court that it was found in the house...
That won't do it for you. People don't understand what guilt is. They understand that on the elements. That's why you have the elements, at least before the court, on the record, that the judge can determine you did. Because normally they say, did you kill the person? Yes, I did. Are you guilty of homicide and you never prove anything about someone was murdered? Certainly you wouldn't say that's enough, right?
Well, I would respectfully disagree that wouldn't be enough, but we have more in this case. You don't have to agree with me.
I was just wondering, why is it not? You assert to us that it was in the master bedroom.
Sure.
But you agree that at the time of the Rule 11 colloquy, it wasn't in the record at all for the court.
Of course, and it wasn't, the district court just needs to be subjectively satisfied. The prosecutor informed him that it was in the house, and the defendant wasn't contesting any of this, and so a reasonable district court could be subjectively satisfied. Whereas if it had proceeded to trial, that's the kind of thing that you would get into on cross-examination.
Only problem, though, you have is that may be true in terms of reasonable, objective district court judge, but also you have an appellate court that is required to have enough evidence before it to make a reasonable and determined jurisprudential decision as to whether or not it was appropriate. And if we don't have enough, then that's a problem, isn't it?
Yeah, absolutely, but the proximity isn't the only thing we have.
Oh, I agree, but well stated, but that's one of the elements. Go ahead, I think you've answered my question.
Sure. And then the last one, looking at the general circumstances of the possession. Counsel stated that this all started with a traffic stop where defendant was stopped. That's not entirely accurate. This was part of a larger investigation that made its way to defendant. And once the investigators had identified defendant, they stopped him. And he readily identified the 8 pounds of marijuana in his car. He gave consent to search 3 residences in Alamance County. At one...
It was corporation on steroids, no question about it.
Yeah, exactly. At one, they found a pound of meth, a kilogram press with cocaine residue on it, and the defendant admitted to pressing 5 kilograms of cocaine recently. The second house, they found 43 pounds of marijuana. And the third house, the defendant's residence, was where they found the small amount of marijuana and the handgun. There was no, counsel said Mr. Davila did not sign off on the PSR's information, but in the record, we have no objection to the PSR information. The U.S. proffered that he possessed the firearm in furtherance. The AUSA specifically said that of his drug conspiracy. And even now, defendant doesn't challenge the factual basis for his drug crimes. He exclusively challenges the factual basis for his firearm crime. And then finally, on the factual basis issue under Carr, we've got the two remedy rule, where if a Rule 11 issue goes to the defendant's state of mind, calls into question whether it was knowing or voluntary, then you vacate or you allow him to withdraw the guilty plea. Here, where it goes to the district court state of mind, whether the district court was sufficiently informed to accept the guilty plea, under Carr, the remedy is to remand to the district court to allow for further, another Rule 11 hearing for the government to offer a further factual basis. And so even if, obviously the government does not concede that there was a factual basis issue here, but even if there were, a defendant would not be able to withdraw his guilty plea. The remedy would be to send it back for the government to put on this additional evidence. And then finally, moving to the Rule 11 cumulative error. Again, because defendant didn't raise this issue below, or seek to withdraw the guilty plea in the district court, it's reviewed for plain error. And as Judge Gregory correctly identified, this is cooperation on steroids. At every single juncture in this case, defendant was ready and willing to cooperate to minimize his sentencing exposure. He entered a written plea agreement, immediately waived a Miranda during the traffic stop and admitted having the marijuana in his car, gave consent to search 3 residences. He gave information about additional kilograms of cocaine he'd been involved with. And he signed a cooperation agreement relatively quickly after his indictment. And this is defense counsel's statement at the sentencing hearing. He was honest up front with the officers, honestly, more honest than they were asking for. He's shown a lot to the court that he intends to get out of it, it being the drug lifestyle, by basically telling on everybody he knows about, unquote. So because this is plain error, you can only reverse if he shows that the outcome of the proceeding would have been different. He wouldn't have pleaded guilty. And on this record, there's just no basis to say that defendant wouldn't have pleaded guilty, even if there were Rule 11 cumulative error, because he did everything he could at every step of the way to cooperate with the government.
Can I ask you a couple questions about the procedural violations in the plea hearing?
Mm-hmm.
What remedy does he have to address those?
Well, are you talking about the Rule 11 colloquy requirements?
The whole thing.
Okay. So if it were an issue with, the defendant's state of mind, so if it were an issue with whether he'd been informed of his right to plead guilty or not plead guilty, something like that in Rule 11 A1.
Do you not see that there were some errors made by the district court here? It's those errors I'm asking you. What venue does he have to address those?
Well, if pressed, the government would concede that there were, some Rule 11 errors. There were Rule 11.
You're being pressed. Don't you think you aren't being pressed? That's why you're up here.
Well, I certainly feel pressed now.
Well, you should be pressed.
There are certain things under Rule 11 that the district court has to inform defendant of.
You told me 10 minutes ago there were no Rule 11 problems. But now you go ahead.
No Rule 11.
Better.
Sorry, no Rule 11 issues with the factual basis.
You have a duty of candor to the court.
With the factual
also,
basis.
Not just to be fair, you have a duty of candor to the court.
Absolutely. Let me clarify. I meant that there were no factual basis issues under Rule 11. The cumulative error, we would obviously concede not everything that the district court was supposed to say was said during the hearing. But I have the initial arraignment transcript with me. There was no prejudice to defendant, and we know that there was no other outcome because every topic that the district court missed was covered in his initial appearance and covered in his plea agreement. Now, the initial appearance transcript isn't part of the record because defendant didn't raise the Rule 11 issue as far as the elements of the plea colloquy, but we'd be happy to submit that to the court. But I can represent that the issues that should have been covered in Rule 11 were covered at the initial appearance. And so defendant was aware of his right to plead guilty, of his right to go to trial.
So, but they are requirements, right?
Absolutely.
So the government this can't be the rule that the government pursues in every case, because it would be just ignoring what Congress or the Sentencing Commission, whoever laid out, so I guess I'm sort of searching for what the remedy is. And what you're saying is there's no remedy.
Well, and that's in the rule itself. In Mitchell versus United States, the Supreme Court, remanded for new plea hearing because they found that Rule 11 hadn't been complied with. In response to that, the rules were amended to add the final provision that any shortcomings in the Rule 11 colloquy are harmless error if they don't affect, are to be disregarded if they're harmless. And so right there built in is a harmless error rule where if the district court comes up short and doesn't make all the statements in exactly the way that it should have, that if the defendant is not prejudiced, that it isn't disturbed on appeal.
So, and you regard that as a limitless ticket to making an unlimited number of errors?
Well, I wouldn't say it's limitless.
The only limit is if you come to this ultimately affected something, right? Otherwise, because I've never seen anything quite like this before, to tell you the truth. Were you counsel at the sentencing?
I was not. And the government concedes that there were Rule 11 issues, but because there was no prejudice to the defendant.
You haven't told us what those errors were yet. I'm just want to observe that. The government concedes there were Rule 11 errors. You haven't specified them.
Sure.
Have you said they were harmless?
Yes.
Yes, Your Honor.
I mean, specifically, you haven't inventoried them and explained why each of them's harmless.
Well, I am prepared to do that, but I do see I'm out of time.
You don't want to do that.
I could certainly do that.
I said you don't want to do that, and you haven't wanted to do that.
So may I go on, Your Honor?
You may.
So if you go to Rule 11(1)(b), the district court has to inform the defendant of the right to plead not guilty or having already so pleaded to persist in that plea. That does not appear in the plea hearing.
That was an error.
That was an error. But the initial appearance, the magistrate judge informed.
This is at the plea hearing. That's what Rule 11 talks about, the plea hearing.
Absolutely.
Colloquy. The plea colloquy.
Absolutely. But if a defendant was actually aware of the information, then it doesn't prejudice him. And at the initial appearance, the magistrate judge told him, at a later date, you will be asked to plead guilty or not guilty to the charges in the indictments against you. If you plead guilty, then there will not be a trial. You will be admitting you committed the crime or crimes charged. On the other hand, if you plead not guilty, then there will be a trial. And at the end, the magistrate asked defendant specifically if he understood.
Do you have a case from this circuit that says that you can go back and rely on what was said at the initial appearance by the magistrate judge in connection with the compliance with Rule 11?
I do. I don't have it handy. I apologize. And I see my time is up. I'm willing to go through the whole rule if you'd like,
But you would recognize that there are a number of errors, correct?
Yes.
Exclude, or several.
There were more than one.
Well, there were more than 3, correct?
Yes.
Okay.
If there are no further questions, I believe my time is up.
You're glad the clock is run, huh? All right, counsel, we'll let you go. Thank you, Mr. Gibbons. Ms. Barrett, you have some time reserved.
Yeah, I just need a minute. I wanted to clarify a couple of things that the government had to say regarding the gun and the factors that Lomax says to apply to determine whether the gun was used, as that term is qualified. And he said that the gun was found in the bedroom of his home, along with some cash. First of all, it wasn't really clear because there were 3 houses that were searched, which one is his home, but we'll go along with that and say that was his home. it doesn't say where in the home exactly the cash was, and,
But
but
it
they
says it's
assume,
found in the bedroom of his home.
not
you
in
just
the, not
read
in the
me.
record, not in the record, it just says in his home, doesn't say where. And the government suggests that because it was found, and that because the Mr. Davila had no other means of income, that it must have been, that the gun must have been there for the purpose of furthering his drug conspiracy. That's not true either, because the PSI does point out that Mr. Davila was an experienced and qualified cabinet maker and had a carpentry business, a shop in Mexico, and had worked for other employers while in this country doing carpentry. So, you know, $14,000 isn't a whole lot of money in the drug trade, first of all, and they don't pin any other money directly to him. There are just so many holes in the facts that I don't think that's a fair assumption to make regarding the gun conviction. And the fact that there was no objection made to the PSI, again, I fall back on the ineffective assistance of counsel as a cause for that, and that if he had been effectively represented, there would have been some objections to that.
Ms. Barrett, go ahead.
Sorry,
Judge
the
Martin.
PSR says it was found in the best bedroom of his home, right? Well, never mind.
It does.
We'll assume it does.
I didn't think so, but I could be wrong. Okay, thank you.
Do you have a question?
Yeah, but Ms. Barrett, it'd be fair, I guess, to counsel who's not present, who's representing about the IEC claim. You have to put that in the context of how much he said about, this wasn't just $14,000 or in a bedroom that's undisclosed at the time of taking it. He sang like a canary. Let me show you what else I did. Over here, don't just, how do you just ignore all that context? Text without context is pretext. So, I mean, how do you do that? I mean, that's not fair. I'm trying to get the best deal I can for somebody who's already been singing with all the notes and at every verse and every stanza.
I hear you.
Let's be fair. I know he or she is not here to defend themselves, but this is not a case like that where we just come with just finding of a search warrant. It was preceded by, let me show you where everything is buried. Well, let me show you there, and let me tell you who else will help me to do it, right?
Well, that's what's in the pre-sentence report. It's not, there was no testimony sworn at any hearing that Mr.
The judge
Davila had.
adopted the pre-sentence report.
I'm sorry?
The judge adopted the pre-sentence report.
Yes, he did.
It was
So that's the record.
Okay.
it's to your client's advantage not to say all those things out in public, right? Did he really want to tell about how much he
You
cooperated
have
with
to
them?
remember, too, that he wasn't an English speaker. I don't know how much he knew of what was happening at all, ever.
Okay.
Did you read his statement that was in Spanish, I guess, that was translated?
Yes, yes.
Well, that's not inconsistent with the rest
Okay,
of this.
I can see that,
So
yes.
keep saying he's not an English speaker doesn't get you so very far.
Well, it may get you past the point of no return for him.
May.
Anything else?
I think that's it. Ms. Barrett, thank you so much. And I note that you're a court opponent, and I just want to say on behalf of the Fourth Circuit, we thank you so much. We rely upon lawyers like yourselves to take these cases, and I want you to know that we appreciate it very much. And Mr. Gibbons, of course, your able representation in the United States is also duly noted. We'll come down, Greek Council, and proceed to our next case. Mr. Thor, when you're ready.
Good morning, Your Honor, and may it please the court. Jim Thor here on behalf of the appellant, Mr. Michael Draven. This matter comes before the court on a certificate of appealability issued in December to address the effect of Davis and Taylor on Mr. Draven's successive 2255 motion. It's clear under Davis that was as this court has held, it was a new rule, retroactively applicable, and Mr. Draven filed his successive motion within 1 year of the Davis decision. And that, we believe, addresses the procedural default issue. We construe the government's argument really to be one of prejudice, which I will get to. But in light of Taylor, the ruling in Runyon, I know the Chief Judge is very familiar with that, from 2020 and amended 2021, that the ruling in Runyon that conspiracy to commit murder for hire resulting in death is a crime of violence simply cannot stand, because it was predicated on this realistic possibility formula that the Supreme Court rejected in Taylor.
Well, I think that we're all for Taylor. I personally am for Taylor, I will tell you that. But there were two predicates here, weren't there?
There were, Your Honor. So we had the two predicates.
What is your argument with respect to the aiding and abetting?
Well, Your Honor, my argument with respect to aiding and abetting, again, is based on Taylor. And what we've presented is that the formula that Justice Gorsuch applied in Taylor of some act plus an intention to commit is insufficient is indistinguishable from a substantial step in an intent to cause, which supports aiding and abetting liability.
Well, of course, as I read the aiding and abetting statute, it talks about aiding and abetting, right? And Taylor talked about something entirely differently, didn't it?
It did, Your Honor. It was an attempt. So,
And aiding and abetting, there's a whole slew of case law that says that aiding and abetting is exactly the same as the principal offense. So aiding and abetting carjacking is equivalent to carjacking. So it's very different than Taylor.
Your Honor, I concede all of that. I am making an argument for an expansion based on the language in Taylor from the Supreme Court.
But the language in Taylor doesn't go to an aiding and abetting, or it doesn't go to the actual crime. It's all about what the language was in Taylor. Well, and what was at issue in Taylor? What was the standard? What was the act?
It was attempted Hobbs Act robbery,
It was
Your
an
Honor.
attempt. An attempt isn't the crime, and that's what Taylor was about.
Your Honor, I agree. I simply believe that the way the Supreme Court decided Taylor, when you look at what is required to prove aiding and abetting, as this court stated in Burgos, the same evidence that can support a conspiracy can support aiding and abetting liability for the substantive offense. That was the basis of the argument. Now, the issue that the government raised really is directed towards prejudice. And, here there is the carjacking resulting in death predicate. And we have this split in panel opinions as to what is required to be shown. Runyon stated quite clearly that if you have a general verdict form and you got two predicates, one is invalid and one is valid, the court is required to determine whether each predicate offense qualifies as a crime of violence. Now, I concede that in Said, which Judge King is very familiar with, there was a different standard applied, which you needed to show more than a reasonable probability that the jury relied on the invalid predicate. If the court rejects the carjacking argument that was made, we still have the issue of, was there substantial prejudice here? Because the jury could have relied at more than a reasonable probability on the invalid conspiracy to commit murder for hire resulting in death. And I think when you look at the record, we satisfy that standard. If you look at the government's closing, in addressing count 5, page 1577 of the joint appendix, the prosecutor said, once they start this conspiracy, once they all make this agreement, that one actor can follow through this agreement and commit the crime for them. So the theory presented to the jury on count 5, the 924J, was predicated on the conspiracy. And here, the carjacking and the conspiracy to commit murder for hire were not coextensive. In Saeed, Mr. Saeed was in the skiff when they attacked the Ashland. So when the firearms were discharged, Mr. Saeed was in the skiff. The conspiracy brought him there. If the court looks at Ali, Ali was the getaway driver. He participated in the robberies. He dropped a bag of money as he left one of the robberies. That's not the case here. Mr. Draven was not in the car. Mr. Draven was not present for the carjacking resulting in death. And we think that distinguishes Mr. Draven from Ali and Saeed if the panel follows that line versus the Runyon-Simmons line, which simply said that both predicates have to meet crime of violence criteria on a general verdict form. So
But you don't get into any of that if you just look at the aiding and abetting offense. It's a predicate, right?
Your Honor, it's a predicate. If the court rules it's a predicate, you still then, if the court were to follow Saeed and Ali, you would still then have to inquire, since the general verdict form, is there more than a reasonable probability that the jury relied on the invalid predicate? Conspiracy to commit murder for hire resulting in death after Taylor is not a crime of violence, because that realistic possibility that the Runyon court relied upon has been abrogated by the Supreme Court in Taylor. There is no mens rea required for resulting in death. All you need is causation. That's what Burrage teaches.
But we're now here on 2255, right?
I am.
So you have to show prejudice. And if you have a valid predicate, there isn't prejudice.
I disagree with Your Honor in that if you have a general verdict form where the jury was not required to identify the predicate to support the 924J conviction, then if I can show more than a reasonable probability, if we're applying Saeed and Ali as opposed to Simmons and Runyon, then that valid predicate is insufficient to support the 924J. So this case has been interesting because it's when it started in June of 2020, it was pre-Runyon, it was pre-Ali, it was pre-Simmons, it was pre-Saeed, it was pre-Taylor. So it's been an interesting journey. But for the law applicable today, if you look at the Saeed construct, there's no doubt there was a general verdict form. There's no doubt that there were two predicates that went to the jury purportedly to satisfy the 924J in count 5. One is conspiracy to commit murder for hire resulting in death, which post-Taylor, we argue, is not a crime of violence, even though it resulted in death, because, as Justice Gorsuch said, the only relevant question is whether the federal felony at issue always requires the government to prove, beyond a reasonable doubt, as an element of the case, the use, attempted use, or threatened use of force. And when you look at Borden, recklessness could be the cause. When you look at Burrage, it's simply but-for causation for resulting in death. So post-Taylor, a conspiracy to commit murder for hire resulting in death is not a crime of violence. That's what Davis, Taylor, Borden show us. So we have this general verdict form. What did the jury rely upon? If you apply Saeed and you require more than a reasonable probability from the appellant that the jury relied on an invalid predicate, I believe that unlike Ali, unlike Saeed, Mr. Draven wasn't in the car.
He what?
He was not in the car. The carjacking occurred over a course of a couple minutes at the bank.
But he was convicted of aiding and abetting the carjacking.
Correct, Your Honor. But this is the use or carrying of the
Aider and
firearm.
abetter is a principle.
Correct, but
He was
that's,
convicted of carjacking.
he was convicted of aiding and abetting the carjacking.
And aiding and abetter is a principle. That's what Section 2 of Title 18 says. An aider and abetter is a principle.
True, but we're here for count 5. And count 5 involves, as charged, was carrying or use of a firearm. And the conspiracy lasted for months. The carjacking lasted for minutes. It's important also that Mr. Draven wasn't charged with conspiracy to commit carjacking resulting in death. It was conspiracy to commit murder for hire resulting in death. So as he's not in the car, unlike Saeed, who's in the skiff, and Ali, who is the driver and at the robbery.
Aiding and abetting the carjacking.
Your Honor, but I don't concede that that gets you to the 924J. Because again, the jury, there's more than a reasonable probability, again, if we apply Saeed. Oh, I've gone way over my time. I'm sorry.
You may continue.
There is more than a reasonable probability if
Where do you argue in your brief, the argument you're making right now, that there is, what in your language, more than a reasonable probability that the jury relied only on the conspiracy predicate?
I did not, Your Honor.
Okay, good, because I thought I'd missed it.
No, I did not. What I argued in my brief, Your Honor, is that the prior panel opinion should control. Runyon,
Prior opinion.
in Runyon, Your Honor,
Yes, but if we go and look at the other predicate, we'd never get into that.
Your Honor, I respectfully disagree, because when you read Runyon, what Runyon says is, since we have 2 predicates, they both must qualify to be as crimes of violence because of a general verdict form, and then it analyzed. Very quickly, the carjacking said, carjacking we need not deal with very often. Evans says carjacking is a crime of violence. And then they spend extensive analysis on conspiracy to commit murder for hire resulting in death to establish at that point, pre-Taylor, that conspiracy to commit murder for hire resulting in death was also a crime of violence. So it's interesting, of course, because Runyon, of course, is this case. Runyon is Mr. Draven's co-defendant. So we have, this court opined in this case that that's the analysis you follow on a successive 2255 when faced with a general verdict form. Now, I can see that Ali and Saeed did different
In
things.
this case, in the district court, it's not in this case in the appellate court.
Your Honor, I misspoke. That's correct. I blurred those lines. But it's not law of the case, certainly not. It's an interesting, I think, comparison in that the facts are obviously the same. The predicate here, not speaking in terms of conviction, but the predicates in terms of the factual basis are the same.
But in Taylor, the Supreme Court talks about an intent is just an intent. That was the basis. And you don't get to violence necessarily because it's just attempts. But here, doesn't it have to result in death? And we're saying that's an act of violence itself. And that was the intent of the conspiracy. So even though it is conspiracy, which normally, conspiracy to commit, Hobbs Act robbery is not enough now. We know that an attempted is not. But here's a conspiracy to hire someone to kill someone, and it didn't stop there. I agree. If it stopped there, then that would be Taylor, because that's an intent. It's intent. But it says no. It must result in death. And so why is it that the violence there, which is the mens rea, which that was your intent to do so, even if, let alone the aiding and abetting, it just might say you're attributable to all the conduct. But as your problem, both have to fit in a general verdict. I understand it's a good argument. But now I'm asking you, why is it covered? Aren't you distinguishing from, isn't it distinguishable from Taylor? Because Taylor, that was just the intent. But here, this requires someone to die because of your agreement to hire to kill.
Well, Your Honor, I believe that, and I'm going to run out of time.
No, you're okay right now.
When you look at Taylor, it specifically eviscerated this realistic possibility. And Runyon conceded there was no specific intent necessary for the resulting in death. There was no mens rea for the resulting in death. And it relied upon its analysis that since there was no realistic possibility that anyone would be charged with conspiracy to commit murder for hire resulting in death based on accidental negligent conduct, therefore, it was a crime of violence. And that is what Taylor has definitively, I believe, invalidated. So you can commit, theoretically, and I understand we get to strange places with the modified categorical approach, but we can get to a place where conspiracy to commit murder for hire resulting in death can happen recklessly, can happen negligently, can happen accidentally. And that is not the use, attempted use, or threatened use of force, which defeats it being a crime of violence.
But you had the mens rea to kill.
You have the mens rea to
And that's the idea of the mens rea is that it's, okay, let's say you're right. It may not have happened like, are you talking about a situation where you go to kill someone and they see you come in and have a heart attack? You're saying that wouldn't necessarily be, it could be completed and it's not violence. But it was your intent to kill them. So, I mean, so isn't that different? And it was completed.
Your Honor, but categorically, it could have been completed in any of a number of ways that would not involve the use, attempted use, or threatened use of force. It could have been completed. Because again, the mens rea doesn't extend to the resulting in death, and Runyon concedes that. There's no, and when you look at the jury instruction here, it was but for causation for element, I think it was 4, maybe it was 5, and the death of Corey Voss resulted. So there is no mens rea for the conspiracy for the use of force to result in death. And that, I think, is the distinction that we have now post-Taylor, which I believe abrogates Runyon's analysis.
Okay, thank you. Mr. Cook?
May it please the court. The carjacking resulting in death predicate readily resolves this case.
Could you address, I guess I haven't understood. I thought that too, but then he suggested to me that that wasn't so. So could maybe you address that argument head on?
Sure, and I'll break it into a couple of parts, and Your Honor, feel free to tell me if I'm not addressing the part that most interests you. The first part is carjacking resulting in death a crime of violence? As to that question, this court held in Evans and reaffirmed it in Runyon that it is a 924C3A predicate. The defendant, as I understand it, his only argument to say that it isn't is to say, well, you had to have aiding and abetting liability here, and Taylor somehow altered whether aiding and abetting liability affects that a crime that otherwise fits under 924C3A does not. And as this court's held in Ali and in Said, and the Seventh Circuit recently in the Worthen opinion had an extended analysis of why Taylor doesn't change that. It just doesn't. So the aiding and abetting carjacking resulting in death, a completed carjacking resulting in death, satisfies 924C3A. And I would add, in this case...
I'm sorry to interrupt you, but I thought the gist of his argument, or the gist that I took from it, probably there were many gists to it, was that you have to prove both. You have to also show that the other thing that he's charged with, in other words, there can't be a way out that something is not a crime of violence.
I think I understand. So there's the first issue is carjacking resulting in death, a crime of violence under 924C3A.
I don't
Second
think
issue,
he said
right?
that it wasn't.
Yeah, the second issue is, okay, there were two predicates here. Does one bad predicate mean that it's not a valid 924J? And on that, I think he's got some distinct arguments, and let me address each one. I'll start with his argument that, okay, assume that the standard in Said and Ali about harmlessness is controlling, which it is, and I'll get to a moment why it is. But under Said, the defendant, since this is collateral review, has to show not merely that it was impossible to tell under which prong the jury convicted, or which of the predicates. He has to show that that the jury found him only guilty on the bad predicate. And in this case, you really don't have to parse the harmlessness standard that much. And let me walk through why that's so. The jury found separately from the 924J both predicates. So the jury convicted the defendant of carjacking resulting in death, and the jury also convicted him of conspiracy to commit murder for hire with death resulting.
That was in counts 1 and 2?
That's right. So
And
those
count 5 is the other one.
Right, that's right.
On the same piece of paper, they convicted him of the substantive thing.
Right. So you don't have to wonder whether the jury thought this defendant was guilty of carjacking resulting in death. They found him guilty of that. So we have a record that we know the jury thought that. What's left then is, okay, you have to show, the government clearly has to show the relationship between the predicate crime and the firearm. So here the 924J charged that the firearm was used or carried during in relation to each of the predicates. The nature of the carjacking resulting in death elements go a very long way to answering that question, because we know that in finding the defendant guilty of carjacking resulting in death, the jury found that the victim, Corey Voss, died. The only way that Corey Voss died was being shot. And so I don't even see how on this record you could think that the jury thought that that the firearm wasn't used during in relation to the carjacking, because in finding carjacking resulting in death, they found the victim died, and the only evidence in the case about how that death occurred was from gunshot. And so it just is, I don't think you have to look at refinements on the harmlessness standard to say that, of course, the jury, if they were presented only with a 924J that had simply carjacking resulting in death, would have convicted, because they found the defendant guilty of carjacking resulting in death, and built into the elements of carjacking resulting in death is all the fact-finding that would get you to the 924J firearm elements that you have to meet. And I mean, separately from even the conviction on the 924J, the evidence overwhelmingly supported it. And so there just is not a reasonable path for the defendant to meet his burden of showing that he was harmed by having the conspiracy to commit murder for hire with death resulting predicate in there, and that's assuming that that's a bad predicate. I think this court's precedent in Said and Ali about how you do the harmlessness analysis on this record dictates a loss for the defendant on his challenge to the 924J. Now, let me turn to his argument that Said and Ali are really not controlling precedent. And his argument there is that when the Runyon panel opinion came out, which predated Said and Ali, it somehow dictated that you couldn't do this fact-based harmlessness inquiry. And that's simply not tenable. There's some language in the Runyon opinion that could suggest what the defendant is saying, but in Runyon, the government moved for panel rehearing and said, look, you had this language in there about the harmlessness standard that's wrong, and the court, and this is if you were to go and look at the docket in Runyon, the government's panel rehearing petition is docket 106, and the court's order granting panel rehearing is 110, and the court struck the sentence, and if one predicate offense does not qualify, we would be required to vacate the conviction. So the court
Struck that language.
struck that language. Then, when Ali came out, the defendant in Ali filed a petition for rehearing en banc saying, look, Ali is in conflict with Runyon, and Ali at that stage was very ably represented by a Supreme Court practitioner from Wilmer-Hale who argued that there was this conflict between the Runyon panel opinion and the Ali opinion, and this court appropriately denied rehearing en banc, and then the defendant filed a cert petition and the Supreme Court denied cert. I'm not aware of any court of appeals having rejected the basic harmlessness analysis that flows from Ali and Saeed. So what the defendant's really just kind of grasping at straws here. There is not a credible argument that the standard laid out in Saeed and Ali is anything other than the binding precedent of this court. I mean, at worst, what you would say is the language from the Runyon panel opinion was just dicta because they said both the predicates were valid, and so you don't really have to talk about what happens if one of them is invalid. But again, I think the court modified the opinion to such an extent that it should not be treated as having decided the issue, and this court went on and has treated Runyon as not having decided the issue, and that's the law of this circuit. And so the standard from Saeed and Ali about how to do the harmlessness analysis controls. Also, I would say that as to the Runyon panel opinion that predated Saeed and Ali, it couldn't have affected the Supreme Court's precedent about how to handle alternative theories where one is erroneous. And we know it's well-settled law that the jury is the one that decides whether the predicate crime of violence was committed. You know, the jury decides whether the defendant is responsible for carjacking resulting in death or the conspiracy to commit murder for hire. And the jury decides whether that crime has the requisite relationship to the firearm. And in light of those being both factual inquiries, it's just directly controlled by the way the Supreme Court is analyzed in cases like Yates and Skilling and Pulador, that you just look at using normal harmlessness principles. And the normal harmlessness principles here lead you back to the point that, like, the jury did find this defendant guilty of carjacking resulting in death, and those findings show that the jury accepted that a firearm furthered that predicate because that's how they killed Corey Voss.
So your position that Taylor had no impact on our precedent at all, that line?
Not as to the carjacking resulting in death. You can have the separate discussion about the conspiracy to commit murder for hire predicate. And
You only have to have one of them, is your position.
right, and so you don't have to reach that question in this case. You could simply decide that the carjacking predicate suffices under Ali and Saeed to uphold this 924J and stop there. And, you know, I would encourage the court to do that because I think it is a direct application of controlling precedent that is entirely uncontroversial and dictated by the record, and it makes it short and easy work of this case.
Did you want to hear the other argument? No.
Anything further?
If the court has no further questions, I'd ask that you affirm.
Thank you, Mr. Cook. Mr. Thur, you have some reserved time.
Thank you, Your Honor. To address briefly the comments by my colleague, yes, I agree that there was clear use of a gun in the carjacking resulting in the death of Corey Voss. And it is clear from the record that Mr. Draven was convicted of aiding and abetting that offense. But count 5 is different. Count 5 simply asks whether my client aided and abetting the use and carrying of a firearm related to one of the two predicates. It did not specify in the finding of the jury in count 5 that it relied upon the carjacking resulting in death. So that does not satisfy, that doesn't answer the question here, even if the court were to apply a Said. I will also note that when...
So say sorry, I can't speak today, accept your argument on that. Where do we go then? So that gets rid of one count, in your view.
Right, Your Honor, and that's the issue here of Mr. Draven has the 3 life sentences as we stand here today. He's got the mandatory life on count 1, he's got a term of years but imposed life on count 2, and he's got life on the 924J. And if the court were to invalidate conviction on the 924J, he would still have 2 life sentences. But we are arguing that the court nevertheless remand under the sentence packaging doctrine so that the court can review the sentence on count 2. And the reason for that is, as the court knows, the law changes. When he was convicted in 2009, and now we have had really a sea change between the First Step Act, between compassionate release and modification of sentence. And we believe that we're taking the long view, that over time, if the conviction on count 5 is vacated and he is resentenced on count 2 to some term of years, that will ultimately help him down the road for a potential modification of sentence, compassionate release motion, or in the event there is a change to the law that removes the mandatory life sentence on the 1958A conviction. So that's why the remedy we ask is that the court vacate count 5 and remand for resentencing under the sentencing package doctrine. I would also like to point out that Mr. Cook is absolutely right that in Runyon, one line was omitted, but the language I quoted to the court in my opening argument was not. I mean, the court nevertheless did say that we are required to determine whether both predicates are crimes of violence. That language was not stricken from the opinion. And it can't be dicta, because if it's dicta, then the Runyon court's entire discussion of conspiracy to commit murder for hire resulting in death would be dicta. It could have simply said, carjacking resulting in death is a crime of violence, we're done, and the rest of the opinion, until you get to the death penalty phase argument, would have been unnecessary. Well, that's certainly not what the government is arguing here. So there was a reason why Runyon addressed both, and we would ask that the court acknowledge that with Taylor, the analysis on murder for hire resulting in death, conspiracy to commit murder for hire resulting in death, is no longer a crime of violence. If there are no further questions, I have no further comments.
Thank you, Mr. Thur. Mr. Thur, we note that you were a court opponent in this case, and we also, on behalf of the Fourth Circuit, appreciate your helping us on these cases. They're very important. We want you to know that we thank you for that service.
Thank you, Your Honor.
Also, Mr. Cook, we note your able representation of the United States. We're going to ask the clerk to announce a brief recess.
This honorable court will take a brief recess.
so I don't want to look like I'm... Well, like, look at this. It just goes way back, so I don't want to, like, if you lean back a little bit, it'll look like I'm dozing off or something. It's just not the message I want to send.
Oh, please, yes. We hid yours. I didn't do that. No, we hid yours on the other side.
Okay, I didn't
Yeah, that's
see them
okay.
for a second.
That's
Sorry about
okay.
that.
It does not matter.
Ms. Tarleton?
Thank you, Your Honor. Good morning, and may it please the court. Jackie Tarleton for Donovan Hall. The government agrees that Mr. Hall has established plain error on his Rahafe claim. So the only dispute is whether he has established that it affected his substantial rights. It did. At the time Mr. Hall pleaded guilty, he had nothing to lose by going to trial. His guideline range with or without trial was the statutory maximum of 120 months. He did not cooperate or obtain a 5K. No state charges were dismissed as a result of his federal guilty plea. If he had known the government had to prove that he'd been convicted of a crime punishable by more than a year, there is a reasonable probability he would have gone to trial. At the time Mr. Hall possessed a firearm in 2015, he had never served more than 9 months in prison after pleading guilty. He had only 2 legally qualifying felonies, one from 10 years earlier and the other from 15 years earlier, at ages 25 and 20 when his frontal lobe was still developing. He was an 8th grade dropout at 15 years old. He'd never been to federal court before, so it would have been unclear to him what the status of his prior convictions would be for federal sentencing purposes. He was a serial misdemeanant in state court, so it's not at all surprising that he wouldn't have known he'd been convicted of a crime punishable by more than a year, even though he'd had a substantial criminal history.
Add more slowly.
Of course, yes, Your Honor. My apologies.
No.
Just to recap a bit, because I was moving quickly, at the time Mr. Hall possessed a firearm in 2015, he had never served more than 9 months in prison after pleading guilty. He had only 2 qualifying felonies. One was a decade earlier and the other 15 years earlier, when he was 25 and 20 years old.
Didn't his lawyer tell the judge at the plea hearing, or the sentencing hearing, that he only had 2 felony convictions? He'd been arrested 30 times, several times, but only a couple of them were felonies.
He had more than 2 felony convictions under the state's designation, but for purposes of Simmons and the Rahafe status.
Didn't the lawyer use the term, the counsel used the term felony?
She talked about his prior felonies.
She
did.
told the judge, in his presence, at the sentencing, he only has a couple of felonies. He's had a lot of arrests, but they haven't been that serious. And she was trying to downplay his criminal record, and to her credit. He's not as bad as he sounds. He's been arrested a lot. But most everything has been a misdemeanor, or it's been dropped. And only a couple of them are felonies. Something like that. I don't quote it, I don't have it in front of me. I remember reading it, though, in this record, maybe several months ago.
She did, Your Honor, but if you're speaking about his knowledge at the time of either the plea or the sentencing hearing, I don't believe that's relevant for Rahafe purposes.
No, but on the Rahafe questions whether he knew it, I thought, had some knowledge of it. And his own lawyer told the district court. That's what I thought.
She
Is
did.
that not relevant? That his
No,
own lawyer told the district court in his presence? He's a felon.
No,
And only a couple times.
I don't think it's relevant, Your Honor, because the
Okay.
question Rahafe asks is what Mr. Hall knew at the time he possessed the firearm, which was in 2015,
Understand.
2 years prior to his
That
plea
might
and
be
sentencing.
circumstances that could be raised, yeah.
So I think the relevant question at this point is what he knew in 2015 and whether there's a reasonable probability that he would not have pled guilty if he knew that the government had to prove that knowledge of status.
And what was the time of the guilty plea, and what was the time of this lawyer, his own lawyer, telling the court in his presence that he's a felon?
His guilty plea and sentencing were in 2017, 2 years after he possessed the
This case has been
firearm.
around here a while.
He has. This case has been pending in this court for 6 years. And so I think it's important to take the court back to that question and that moment in time when Mr. Hall entered his guilty plea and what he knew that the government had to prove. And at that point in 2017, he had no reason to believe, and the government had no reason to believe, and his lawyer had no reason to believe that his knowledge
Had
of
no
his
reason to
status.
believe, you say, but based on what his lawyer said at that sentencing, the lawyer knew that he was a felon.
The lawyer was
And
making.
you can argue the legal definition of a felon. You can argue that really he wasn't him speaking. He was standing there, I'm sure.
His
My way I
counsel,
picture
Your
sentencing.
Honor, was not speaking at all to his knowledge in 2015. She was speaking about the legal facts of his criminal history as they existed in 2017 as he went before Judge Boyle for sentencing, which I don't believe is relevant to this court's inquiry today. I think it's important for this court to look both at what the government would have had to prove and what Mr. Hall would have stood to gain by entering a guilty plea rather than pleading guilty. And in this case, as I began my argument, he had nothing to lose. He got no benefit from entering a guilty plea rather than going to trial. So I think this is the unusual case that this court contemplated in Hayward and that the Supreme Court contemplated in Greer, where the defendant can in fact make a showing that there's a reasonable probability that if he'd known the correct elements of the offense, he would have gone to trial. I'd like to make two other points about his prior felony convictions. In each, Mr. Hall received a sentence of 11 to 14 months. In the first case, it was suspended. In the second case, it was activated at the outset. But in both cases, under North Carolina state law, Mr. Hall would have been reasonable to believe that he would serve only 11 months. And that's because in the absence of any infractions, that would have been the sentence he would have served, which of course is less than a year. So it's reasonable for him to have believed that any additional time that he served would have been attributable to prison infractions and not to the original offense of conviction.
Well, he can't have a reasonable belief that is contrary to fact. I mean, it was punishable by more than a year, right? He has to know, I mean, we can't just excuse that because, well, he thought that it was only punishable by 6 months. I mean, you know, that's not, I don't exactly know where that goes.
I don't think that's quite right, Judge Motz, under Rahafe and Greer, which is that Greer itself contemplates that there could be what they call a confused probationer, someone who was in fact convicted of a crime punishable by more than a year, but nonetheless did not know he was because, for example, he served no time in prison. So there has to be some meaning to what Rahafe said, which is that even someone who legally has the status of being convicted of a crime punishable by more than a year, there's this additional thing that needs to be proven by the government, and that's his knowledge of that status. And so the mere fact of a qualifying felony conviction cannot be enough, or Rahafe would be
No, I didn't
meaningless.
say it could be enough, but I thought that you were suggesting that he didn't know that this was punishable by more than a year. Is that what you're saying?
I'm saying there's a reasonable probability he would have gone to trial if he knew the government would have had to make that showing. And so I don't think it's unreasonable for him to have said, I'll roll the dice and go to trial, because I think this is confusing.
You
On the
rely on
things
Hayward, right?
we do.
So it's a lot weaker case than Hayward, though, isn't it?
Well, I think, Your Honor, there are case-specific facts in each of our cases that are distinct from one another. And I don't think that Hayward requires a contemporaneous expressed desire to go to trial in order to result in relief. I think that Mr. Hall has these unique circumstances of his youth at the time of his prior convictions, the fact that he was in fact an 8th grade dropout at 15, so he was already behind in school. He'd never been to federal court before, so he didn't know the status of his prior convictions for federal sentencing purposes, and he was in and out of state court and state prison throughout his life, so it's not at all surprising that he wouldn't have fully understood which period of time was attributable to which conviction. And again, he had nothing to lose by going to trial. So there's no reason for this court to doubt that if all of this would have had to be proven by the government to a jury in his felon in possession case in 2017, that he reasonably might have gone to trial. I would like to spend a few moments on our Singletary and Rogers claim also. Rogers and Singletary make plain that the remedy for this error is a plenary resentencing. The government has never quarreled with our articulation of Rogers and Singletary error. They seem to agree that the district court failed to orally pronounce 16 of the discretionary conditions to which Mr. Hall was subject. And they've never, they have, essentially what they're asking is for this court to penalize Mr. Hall for winning on another issue in the Supreme Court and then raising this claim after it was decided, which was after the Supreme Court's GVR. So I don't think that that's sensible under this court's precedents. Judge Motz's decision in Sisson, I think, is informative.
Has the government ever conceded the Rogers error?
They've never contested it, Your Honor. They've never said.
No, that's not what I said. It's what you said. Did they ever conceded it?
I don't believe that they've gone so far as to say that.
They declined to address it.
They declined to address it.
They declined to address it because a prior panel of this court denied your request to file a Rogers brief.
This court
to brief the Rogers issue.
Denied my request to file a supplemental brief. And respectfully, Your Honor, I did not file an additional brief on this issue and simply included it in my principal brief because I think it's so important. I take seriously.
But they just simply said, we're not going to reach it. And now they've said, actually, in some papers, that we ruled in their favor by not letting the brief be filed on the merits of it. But I didn't know whether they had conceded the error itself. You said they haven't contested it. That's I take it to be acknowledgement that they haven't conceded it. They just haven't joined the issue.
I don't believe they've ever used the word concede or concession or confess error, but I have noticed in other cases.
If it is an error, they don't argue that it isn't.
That's correct. And I have seen in other cases where they've said, first of all, this shouldn't be considered by the court, and also no error exists, and they haven't done that in this case. I would note that this court generally tends to treat cases alike. In other cases, including Boddy, Everett, Guthrie, Torralba Amador, Hill, Robinson, Whiteside, this court has allowed this claim to be considered even if it wasn't raised in the opening brief filed by the defendant. And again, the procedural posture of this case is unique in that Rogers and Singletary were not decided until after Mr. Hall had already obtained a GVR victory from the Supreme Court and come back, was on abeyance in this court.
What kind of relief would you get out of the Rogers error?
Out of Rogers and Singletary, the relief we would request and what this court has authorized and said is required in Singletary is a plenary resentencing. I would note also that if this court declines to address this issue, the impact would be that these conditions would be a nullity and Mr. Hall would in fact not be subject to them on supervision. I'm not sure that's the result the government would like, but I think that is the natural implication of this court's decision in Singletary because they were not in fact orally announced at sentencing. I'd also like to note, I mentioned this in our brief, these are not sort of ticky-tack conditions of supervision. One of them includes warrantless searches, which is a very significant intrusion on Mr. Hall's liberty, and it was never announced at sentencing. It was just slipped into the written judgment after the fact, especially where such a significant erroneous deprivation of liberty is implicated. I think this court does need to correct that error by sending it back to the district court for resentencing. The government has relied heavily on the mandate rule, but I think it's important to recognize the two exceptions to the mandate rule, which are that when there's controlling legal authority that has changed, this court will address it.
Does that implicate the Rogers and Singletary cases?
Yes, I think so.
Is that what you're saying?
I think so. Judge Motz's decision in Sisson is instructive on this point. In that case, the court said it would blink at reality to say that the argument was just as available before we decided Rogers as it is now. I think that's certainly true. This court has pulled cases from Anders' briefing to address Rogers and Singletary, and I think it is an important correction that needs to be made. I would also note that government cites in its 28J letter, its response to my 28J letter, United States against McCormick. And the footnote that it cites says exactly, when the Supreme Court remands a case with specific instructions, the appellate court must confine its review to the limitations established by the Supreme Court's remand order. Accordingly, this is the important part, absent an argument that there has been intervening controlling precedent, we will not reconsider McCormick's sentence.
And what are you arguing?
And that's all we've asked this court to do, is to consider intervening controlling precedent of this court.
You're arguing intervening controlling precedent. Is
Absolutely.
that your position?
Yes.
So you're saying McCormick supports you
Yes,
on that point?
yes, I think so. And I think
Are you arguing that they've waived any right to contest the Rogers question?
I don't think
They refused to brief it.
Yes, yes, certainly. And for those reasons, Your Honors, we would ask that this court vacate Mr. Hall's conviction, and even if it does not, vacate his sentence and remand for resentencing under Rogers and Singletary. No further questions.
Thank you, Ms. Tarleton. Mr. Bradgun.
I'm a little puzzled about the government's reaction to the Rogers claim. Maybe you can clarify things for me.
Well, Your Honor, I'll say a couple things. I think from the government's perspective, we thought that the court was taking the Rogers claim off the table by denying defendant's request for supplemental briefing. Defendant requested supplemental briefing on this issue. We responded to that, and I'll go into this in more detail in a minute, but we responded that the posture of the case means that this issue is waived. And there was a lot of discussion of whether or not there was a change, a dramatic change in controlling legal authority or not. And this court ultimately said, denied the request for supplemental briefing. From our perspective, there was...
It was included in the defendant's brief, right?
Well, I think that the way we understood the request for supplemental briefing, it was to add this as an issue to what the defendant
I understand your argument, but then I'm just asking you as a fact question. In fact, it was included, the Rogers argument was included in the defendant's brief on merits, right?
It is.
And did the government respond to that?
We responded only to say that the court had denied supplemental briefing.
So you didn't respond on the issue.
We did not respond on the issue.
You waived a right to respond to the issue.
Well, Judge...
When you waived the right to respond to the issue, were you waiving a right to come up here and argue today? You haven't briefed the issue for us.
Let me tell the court, first of all, we would concede that there's Rogers error. So I want to take that off the table.
That should have been said in your brief.
Your Honor, respectfully, we disagree. We think that when the court denies supplemental briefing on an issue, that the government should not have to respond on that issue. And I think if the court wanted us to respond on that issue, it should have granted supplemental briefing. And even now, I think that...
You're going to blame us for the fact you didn't respond.
Your Honor, I think that the court's... I don't think that our reading was unreasonable in understanding the court's order to say that this issue, that it did not want briefing on this issue. And so we took that as the appropriate response. Now, we do concede error on that issue, and I don't want to shy away from that.
But what's the relief they get?
If the court does not find this error to be waived, they would get a new trial under a new sentencing under Rogers and Singletary.
Plenary sentencing?
What's that?
Plenary sentencing.
Yes, Your Honor.
That's what Singletary.
That is what Singletary. the other circuits have not applied that remedy, and I think it's an
that's our
interesting
precedent.
question, but this
Rogers
court
and
has,
Singletary.
absolutely, yes.
Together.
That's the remedy that this court has applied to Rogers' error, absolutely. And so, but I would like to say a few words to reiterate our opposition to supplemental briefing as to why this issue shouldn't be before the court. And I think that...
Are you sticking by the mandate rule?
Yes, Your Honor.
Well, the mandate rule, the case you cite, she read to us, it talks about in the absence of intervening authority.
Well, Your Honor, there's a difference between the
It's
legal...
unpublished anyway.
Well, but it cites to this court's opinion in Bell. And what Bell does is it sets forth and it gives exceptions. There's 3 exceptions. But in general, when a case is up on appeal and then comes down, the court does not reconsider issues that either were resolved by the higher court or were not raised in the higher court. And so in that case, the only exceptions are one, a dramatic change in controlling authority, and we recognize that exception. But that's very different than the standard.
Does McCormick say dramatic change?
It does say, Bell says dramatic change.
Bell says dramatic change. You don't put, that's not in your letter yesterday. You use the word, you just cite to McCormick.
It is in my letter yesterday, Your Honor. Okay. And I do believe we cite that language, and we cited Bell in our original opposition. And I think that's part of the reason the court ruled in our favor on that issue originally. So it's got to be a dramatic change. So we have to ask, what is the controlling authority? Well, the controlling authority was a line of cases that began in United States versus Morse from 1960s, but it continued all the way up into the 2000s. And what that line of cases said was, if something is not pronounced at sentencing, but it's in the judgment, then what was pronounced at sentencing is binding, and anything extra in the judgment is a nullity. That line of cases existed. And so the question is, was Rogers a dramatic change to that authority? And no, it wasn't. It was just...
Rogers didn't make new law.
It was an application of the authority. Now, I agree that if this court had not gone up to the Supreme Court, the standard is different. The standard for a case that's just pending is whether it's an intervening case is relevant.
You're saying that we'd have to resolve this case on the basis of some law that preceded and ignore Rogers and Singletary.
Yes, Your Honor, and I think it's good to remember that this case is 6 years old. The sentencing occurred in 2017. This court's opinion occurred in 2018, over 5 years ago. And this court resolved issues like procedural and substantive reasonableness. If it sends it back now based on an argument the defendant came up new, it's got to redo those decisions on procedural and substantive reasonableness.
So you say that we decide the case today on the basis of the law was in effect in 2016 or 17?
I think
everything that happened since then, we have to put aside.
Unless it's a dramatic change to a controlling authority, the defendant waives the argument. And the parties get to choose what arguments to raise, and sometimes
if the government doesn't brief it, they waive it too.
Well, Your Honor, respectfully, and maybe I completely misunderstood.
What's fair for the goose is fair for the gander.
We understood the court to be telling the parties not to brief this
issue. They briefed the issue, and you refused to join the issue.
We thought, we believe and still...
You start firing off these letters and coming up today and arguing the issue that you haven't briefed.
I'm not arguing that issue. I'm not arguing Rogers Singletary. What I'm arguing is...
You concede that there was Rogers' error.
Absolutely. What I'm arguing is whether or not it was waived. And I think this court has decided this issue. It decided this issue when it denied supplemental briefing.
So denial of supplemental briefing resolves the issue that the briefing would have dealt with?
Yes.
Okay.
Yes, Your Honor. That is my main argument here. I am happy.
I mean, and the denial of the supplemental briefing is simply an order. There's no explanation attached to it.
Correct, Your Honor. But
If it had said, we deny supplemental briefing because we don't think we need it,
but the parties had
because we understand it and we don't need it, that would, you'd say that's the same thing.
Yes, Your Honor. And the parties did fully brief this issue before the court ruled on it. And so I think the presumption was that the court agreed with the government's argument on this in denying the supplemental briefing. I am happy to address the Rehaif issue as well, but I'll do so only if the court has questions on that issue.
Only have questions. Mr. Alton gave us sort of robust arguments about that issue, and you said you just leave it up to us?
Well, Your Honor, I guess maybe I disagree about whether or not it's robust, so I'll be happy to dive into that. To answer Judge King's...
I'm just making sure you're not doing us a favor. I thought, are you saying it was not worthy of even responding?
Your Honor...
Sure, that's why it came back from the Supreme Court.
Right.
I do not consider
That's why the
this...
cases you're being argued today.
I do not consider this to be a close Rehaif issue, and defense attorneys have conceded that there was no error in similar cases. But let me address the merits. First of all, to answer Judge King's question, the district court, the defense counsel in district court said the most he's been sentenced to is 11 to 14 months. And so not only did they identify it as a felony, they specifically identified it as a penalty that was punishable by more than a year in prison. Defendant twice was sentenced to more than a year in prison. He was sentenced to 11 to 14-month sentences. He had 3 other felonies, but these are the, under North Carolina law, these are the 2 that qualify. And in both cases, the judgment was clear that it was 11 to 14-month sentence. The defendant, in the acceptance of plea transcript that we submitted, that the defense submitted as part of the supplemental appendix, it shows his statutory maximum as exceeding 12 months imprisonment.
Well, it's conceded that he is, in fact, was a felon. That's always. But the point was at that time, once that was done, that's all the government had to do. But Rehaif says, no, it's more. You have to show that he knew that he was a felon. Not the consequences of being a felon, but that he knew. So that's for the whole idea. And Greer says there are cases where a person could put forth facts that would maybe convince the jury, and that's not even the question. It's not whether he would win or not. The question is whether or not it may change his calculus as to whether he would plead guilty. That's the real way, the window. So you're telling me, so all you talked about, that won't help you. Yes, he is a felon. Done. Question is, did he know that we now know that's an element? So now I want you to address the issues that I thought was put forth. Well, I said robust, you said it wasn't. But I thought it was rather thorough that it laid out what conditions, because of his age and situation, the fact that many people associate felony with being in prison for a year, he was not, and all those things like that. I want you to address that, but if that's what I think that needs addressing, but if you think that you're finished, then you can sit down.
Well, Your Honor, I would be happy to address that. And I would start by saying that Greer does say that felons ordinarily know they're felons. And so it's a high standard on the defense to show why they didn't know. In this case, the defendant at the time of sentencing was 36 years old. So he's not young. He's not young at the time of this crime. And so I don't think there's a lot of evidence that he never contested the fact that he had a felony.
He's not young now, but the understanding of the facts then, he was that age.
Well, he would have been in his 30s at the time he committed this offense, Your Honor.
Offenses that made him a felon?
No,
That's what I'm
offense
talking
of
about.
conviction here.
I know that. I'm
Okay.
talking about
You say he's 36 today, or when?
He was 36 at the time he was sentenced in 2017, Your Honor.
But that wouldn't necessarily inform what he understood it to be when he was 20 or 25 years old, necessarily, would it?
Well, he also never contested that he was a felon, and he, in fact, served more than a year imprisonment for each of these 2 felony offenses.
Well, it wasn't relevant at that time whether he contested or not. The only question was he, in fact, a felon. That's the whole point of Rehaif. The Supreme Court started this. You know, I'm long in the tooth on this case. So they started it. I thought it was very important. They said it was important. And then Greer comes back and says, well, it's really not, because everybody knows that, well, if that was the case, then why have Raif? But the point is, it doesn't make, the point is that the fact that he is not the question. And then at least there's a window of opportunity was, well, we will say this. Notwithstanding the language, you're right, I can almost quote it, everybody ought to know they felt it. There are cases where a person may not know, and if they can put forth a plausible argument that they may have changed the calculus as to whether they would have pled, that's there. And it seems like you're not addressing that. You're all of, well, you know, he was, well, you don't think that's a fact, the fact of his age, and the fact that he didn't spend more than 8 months or 9 months in prison? You don't think that?
Your Honor, he served more than a year in prison on both offenses.
In prison?
Yeah, absolutely, Your Honor. And defense counsel says he served only 8 months after he pled guilty, but he had been serving prison time before then. So the total amount.
Was he in jail?
Absolutely, Your Honor.
I said prison.
Sorry. Total amount in custody. The total amount in custody.
But people associate prison with, a lot of times, with felony. Well, you went up to the big house for a year. That's a felony. But if you don't go to the big house, you go to the local jail, the same place that shoplifters go and all those places like that. You associate with, that's a misdemeanor. And that's the point. The question is not whether he would have won. A jury may have said, he knew. Well, that's different. That's not the question. Counsel said he had nothing to lose. Can you address that?
Yes,
That's a very important fact in this case.
I do disagree with that because I think there's a little doubt that if this defendant had gone to trial, he would have gotten the maximum of 120 months. And the court gave him a break of 10 months. It sentenced him to 110 months prison. The court actually didn't want to, even in spite of his plea, and defense counsel argued, hey, give him credit for pleading guilty, among other arguments. And eventually, at the last minute, the court backed down to 110.
You all recommended a downward departure.
I don't believe that we did in this case, Your Honor. I believe we were...
you weren't giving him anything.
We were asking for 120 months.
The judge said he probably mentioned he could get life, or should get life.
The judge would have given him longer or would have considered it, I think, if the stat max had been longer. And so he did get a 10-month break. And Your Honor, I would say, I do think the overwhelming nature of the evidence that he has this conviction does matter to whether a rational defendant would have made that decision. We can't get into the defendant's head, and so what this court says is we're looking at whether or not an objective defendant in this situation would have made the decision to go to trial based on this issue. And given that he pled guilty to 2 11 to 14-month sentences, he signed statements saying that they were punishable by more than a year. He actually served more than a year in custody on each of those. I don't think that any reasonable defendant or rational defendant would have made the decision to go to trial. And he got a benefit. He got a 10-month benefit out of it.
I'm not sure about that. You're saying that, you know now, the best I can do is get 10 months if I plead. But if I'm able to convince a jury of 12 that I really didn't know because of my age and all of those things, I get 0. You think that's not a bad calculation?
Your Honor, I think that there was...
I ask you, is that a bad calculation?
Yes, it's a bad calculation.
Really?
I disagree with, because I think the chance of him convincing a jury of that, and Your Honor, I've been a trial attorney a lot longer than I've been an appellate attorney, and the chance of convincing an attorney, a jury in the Eastern District of North Carolina that you didn't know when you actually served more than a year in custody twice, when you're extremely experienced with the state criminal justice system, with all these misdemeanors and everything else, and you signed a paper saying that your crime was punishable up to 30 months. I can't imagine any jury acquitting on that point. And so do you take...
It takes one person.
Do you take 10 months? Your Honor...
It only takes one person on the jury.
I disagree, Your Honor. If we have one person, we try it again. And we very often win these cases the second time after an acquittal. It takes 12 people for an acquittal. And defendants who have one person on their favor very often...
12 for a conviction as well.
12 for a conviction, but very often you end up with the second trial. And I just don't think that there's any realistic possibility he could have won this, nor any realistic possibility...
What you're doing, in effect, you're writing out what the Supreme Court said.
The court asks us to analyze whether an objective person would have made this decision, and I would ask the court to consider this.
An objective person would have made that decision? That's the question.
Whether a reasonable person in the defendant's position would have decided to go to trial. I'll ask the court this.
And the defendant asks his lawyer for advice on what he should be doing.
And
then you're really going back to a defense lawyer, and ultimately, maybe in this kind of situation, to 3 judges.
That's right. But going back to Greer says it should be a very high standard to find that a defendant who's committed a felony and guilty of a felony doesn't know he's not a felon. And so the presumption is that it is going to be plain error and not violating his substantial rights. And the circumstances they've recognized exceptions to that have been these unusual 3-year misdemeanors where the defendant has contested his conviction in various
stages. The
stages.
circumstances in which they have recognized, who is this they?
Sorry, the Fourth Circuit, Your Honor. I apologize.
So you have a slew of cases that so hold?
We have 2 that I'm aware of. One is Hayward with the defendant cites. The other one is Baronet. And in both of those cases...
Hayward's case, it seems to me, is a lot stronger than this case here. But anyway, tell me about Baronet then.
It's very similar, Your Honor. In both of those, it also
Case
involved...
at hand or Hayward?
Baronet is similar to Hayward. It also involved a 3-year misdemeanor. And the court was concerned... may I finish? I see I'm out of time. The court, I think in both of those cases, was concerned for misdemeanors, it's got to be punishable by more than 2 years in prison and not just more than 1. And the court was concerned in both of those cases that the defendant might not know it was punishable more than 2. And in fact, in Baronet, I believe the defendant agreed he had been convicted of a crime punishable by more than a year in prison. And I said, well, that doesn't tell us whether or not you're admitting to a crime punishable by more than 2 years in prison. And so in those unique circumstances, this court has recognized exceptions. This is very different than this case, and it's not, I do not consider it a close call on the plain error issue.
I know Judge Moss has another question, but in both instances, wasn't the range starting at 11 months?
11 to 14 in this case you're talking about.
Yes. Well,
yes, Your Honor.
And wouldn't that be some sense that a person could be confused that 11 months would be a misdemeanor if he spent less than that? I know in fact that it's wrong. That's not the question. The point, I should say in law, not in fact, but let's say in law is wrong. Because that's the difference. I think that's the key with confusing law and fact. In law, it is a felony. But in fact, people look at facts. Look, I can do 11 months. That's not a year. And therefore, if I have a chance to, in this sentence, to do less than a year, that's not a felony. Now, you think that that's because you're a lawyer. A lot of people who, it's a jury of your peers, not a jury of your lawyers or judges. That's what we're talking about, convincing people who live. A lot of people have a problem with the government in itself. And what about, the government ought to make that clear. That wasn't clear to him. And he was a young kid. His lobe had not fully developed. and things like that, 8th grade education, 15 years old. A lot of people on the jury might say, no, I don't think that he would have known that. But you come here and say, we have to, as an appellate court, yeah, I knew it, you know it, and the jury went. But I think I maybe practice law in terms, maybe as much as you, in terms of defense, criminal defense work. And I've seen jurors do some amazing things, and they call it justice. I don't mean amazing by nullification. I'm talking about amazing by justice.
May I answer briefly?
Yes, you may answer.
Thank you. I do think to address the defendant's age, I think at the time of this second state condition, he was in his mid-20s. And so it's not like we're talking about an 18 or 19-year-old, the second conviction that qualifies. So that's number one. Number two, I do think that most, if not all defendants, would understand that if you get an 11 to 14-month sentence, 14 months is the maximum amount you might serve. Now, you hope that you get the 11, but I think that most defendants would know you might get 14. And all this defendant has to know is that it could be punished by more than 12 months. And I would contend that under the Greer standard, that is met here. Thank you, Your Honor.
Judge Mons had a question.
Yes, I do have a question about the sentence, which no one else seems to be so interested in. But let's just assume that we get to the Rogers issue. This sentencing transcript is disturbing, I would say. Would you agree?
In what way, Your Honor?
Well, in any way you can think of, is it disturbing?
Well, I would say that with respect to the Rogers Singletary issue, certainly the judge did not pronounce the conditions of supervised release. And so I think that, that's the issue I've been focused on with respect to the sentencing.
But if you read through it, it seems to me to be extraordinarily aggressively anti-defendant. Could we agree on that?
Oh, yes. I think the court looked at this crime as being very serious, and it saw the crime as being worth perhaps more than the maximum penalty that it was able to face. I agree with that.
And there's been, in some of the language which the district court used was pretty charged. Now, there has been no claim by the defendant that provides a basis for reversal. But the sentencing, qua sentencing, is before us. And I wonder what you have to say about that, if anything.
I appreciate the question.
I've never read a record quite like this before.
I would say that, judges can sentence in a variety of different ways. Neither this court nor the Supreme Court expects them to do so with no emotion or completely without considering kind of the serious nature of the conduct. In the case of the Rule 11 hearing, this court was very clear that to the defendant that he had risked his life by running from the police and put himself in a dangerous situation. And I think it sees this behavior combined with his criminal history as being very serious.
Let me ask you about two excerpts.
Yes, Your Honor.
The judge told Hall that his life before prison was an insult and an assault on the rest of the community, and that if he had died in his life before prison, it would have been a benefit to the rest of the community. And then he expressed exasperation that Hall, a black man, had slipped the noose of ACA, and that he should probably get a life sentence and be thrown away as someone unworthy of freedom in society.
Your Honor, I think that the word choice of slip the noose was a very poor word choice given our country's history and potential overturns.
You didn't say this, but were you at the sentencing? Were you the...
No, Your Honor, and the attorney who is actually serving overseas with the Department of Justice right now.
Okay, I was just curious. So this goes to the question of if we should find there is error here, it usually goes back to the same district judge. Don't you think there is a rationale for sending this back to a different district judge in view of that language?
I think that if the court is, I would prefer not to take a position on that. I think
But I'm asking you to take one.
if I guess my impression, what I would say, Your Honor, is no. I don't think it needs to go to a different judge. And
Is there ever a basis for us to send a case back to a different district judge then? With this earlier answer in mind. So you would say no to that too?
yes, there are times when it's appropriate to send.
Okay,
I do not read these comments the same way the court does. I read them as indicating that the court considers this behavior to be very serious. I do not read any racial overtones into it. I don't think that the court had any intent to have any racial overtones in it. I think that what the court was saying was the criminal history is extremely serious and the offense is extremely serious. And
Well, our standard is whether we think it would be fair to say that the original judge could reasonably be expected to have substantial difficulty in putting out of his mind previously presented news, and that reassignment is advisable to preserve the appearance of justice.
Respectfully, Your Honor, I understand the concern, but I just do not, I do not see these issues as being something that, to me, I read this transcript and I just read it as indicating the seriousness with how the court felt about the offense and the criminal history, which are appropriate concerns for the court. I do not read it in a different way than that. And based on that, I do not think there's a need to assign it to a different
You represent
judge.
the United States, don't you?
Yes, Your Honor.
A great country, right?
Yes, Your Honor.
That's founded on freedoms and ideals and principles that every person stands equal before the law, correct?
Yes.
What did it serve to mention that he was a black man? Can you tell me? I'm going to give you the ire about the crime, the seriousness, the danger, and even you said the slip of the noose comment. But what did it add to it to say that he was a black man? You tell me. Because you represent the United States.
Judge Motz, I don't remember that specific.
JA 33 and JA 32.
Okay, thank you. Do you mind if I look at the comment really quick, Chief Judge Gregory?
Judge Motz read it clearly, but
But
go
no,
ahead.
I may have, sure.
Maybe, sure, but go ahead. Then when you get it, maybe you could read it back to him.
There are two different sentences.
Right, two different sentences.
Let's see. Okay, so on JA 32, it says, but I mean, the whole idea of ACA is that if you take him, this right here, Mr. Hall, and you take what he did and you profile that against a life of crime, you should not be let out. You should probably get a life sentence and throw you away as someone unworthy of freedom in society. So that's the first
He also talked about slipping the noose.
comment. Yeah, I think that's on 33, right? So
I have it on 32, but I'll
Oh,
look it
okay.
up.
Let me look up.
But I think that your larger point was he didn't say.
Well, did
black
he
man
say
was
black
alive.
man?
He knew the man was in front of him.
Oh, you didn't, he didn't say black.
Right, I didn't, that's why
I thought you were reading
Yeah,
that.
but he
Your
did
Honor, that's
say-
why I didn't want to say
Slip the noose.
I thought you were reading that.
I was reading.
Oh, you were saying
Context.
parenthetically, a black man.
Yes,
Okay.
exactly.
Well, that's better.
Thank
But
you, Your Honor.
Well,
he did
I'm
say
glad.
slip the noose.
Yes, and I
I'm glad
would,
I asked the question because
and to be clear, Your Honor, I would have been much more concerned if he had said black man. I think that would indicate a serious problem.
Not fair enough to you.
Okay.
Yeah.
And fair enough to the judge. Okay, he didn't say that. The slip of noose, he said, but he didn't say that.
Yes, Your Honor. If there's no further questions from the court, I would ask the court to affirm.
All right. Carlton?
Thank you, Your Honor. I'd like to begin with the Rahafe claim. I think it's important for the court to consider the question. This court has instructed that it be answered in these kinds of cases whether there's a reasonable probability a defendant in Mr. Hall's circumstances would have chosen to go to trial, not whether a jury would have been persuaded or whether that would have been a good idea. Although I will note, incidentally, this court's decision in Lockhart, many judges of this court suggested that no jury would ever find that he'd been not known that he was convicted of a felony. In fact, the jury did acquit him on that, on remand. So I think it is possible. And to Chief Judge Gregory's point, it's not always clear exactly what a jury might do. I also think when a defense lawyer is advising their client on whether to plead guilty, there's two sort of pockets of information that are often considered. One is what must the government prove, which we know was defective in this case because no one knew that the knowledge of status element had to be proven to the jury. And the other is what might a defendant gain by pleading guilty? There are a number of ways that can come up in other cases. For example, if a defendant chooses to cooperate to earn a 5K, if the defendant believes that the government's somehow going to concede to, a stipulation or a reduction in sentence, if they're going to receive a benefit from acceptance of responsibility, if they're going to have state charges dismissed. None of that happened in Mr. Hall's case. He didn't receive any benefit for entering a guilty plea. And I think looking at these records in our supplemental appendix, they're confusing. And they're confusing to me as a defense lawyer. His sentence was broken up in all kinds of ways. The first sentence of 11 to 14 months was initially suspended. He was given a 36-month probationary term and a 101-day jail credit as a special condition of his sentence. Later, he elected to activate that sentence. He received jail credit from the time leading up to that activation of his sentence. He also received jail credit for the time preceding his guilty plea, and then he went on to serve an active sentence. In the second case, it was an 11 to 14-month sentence, and as I mentioned in opening, the presumption is under North Carolina law that it would be an 11-month sentence unless he committed an infraction of some kind. So it would have been entirely reasonable for him to believe that he was actually sentenced to an 11-month term. I wanted to address briefly also the government's argument on Singletary and Rogers. Essentially what the government is asking this court to do is to penalize Mr. Hall for winning at the Supreme Court, because my friend on the other side today conceded.
He's conceded now. The government's conceded that you get a remand for resentencing.
They've conceded the error, and I will rest if this court is persuaded.
According to my notes, concedes the Rogers error and concedes that it should be remanded for plenary resentencing. And sorry that he didn't brief the issue.
Yes, Your Honor, and we believe that that relief is appropriate. So on the Rahafe claim, we would just ask that this court focus its attention on that time frame, when he entered his guilty plea in federal court, and whether there's a reasonable probability that under the very specific circumstances of this case, he might have elected to go to trial. So we'd ask this court to vacate his conviction on his felon in possession.
What about Judge Gregory's question to your colleague or Judge Mott's question, Judge Mott's question about whether it should go back to the same judge or whether there ought to be a new judge?
Your Honor,
Government wouldn't take a position.
I do believe that Judge Boyle has handled a number of cases of defendants of many backgrounds, and I believe that he can be fair in this case, especially after the passage of 6 years. But I absolutely respect and would defer to this court's decision as to where to remand it.
All right. Anything further? Well, thank you very much, counsel, the both of you. We appreciate your arguments. I will ask the clerk to adjourn the court until tomorrow morning. We'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.